Hello and welcome to IGPP Expert Talks. I'm Heena Goswami, Editorial Consultant with IGPP, Institute for Governance, Policies and Politics, New Delhi. Today, in our AI special series, we are joined by Ms. Tatiana Rice to discuss the recent debate on veto to California's AI legislation. Ms. Tatiana Rice serves as the Deputy Director of US Legislation at the Future of Privacy Forum. With a focus on artificial intelligence and biometric technologies, she analyzes legislative and regulatory developments and engages in testifying, offering comments, and collaborating with policymakers to enhance their comprehension of technology and the law. Her aim is to establish ethical guidelines and safeguards that promote responsible innovation and deployment of emerging technologies while maintaining individual data privacy and civil rights. Welcome to IGPP Expert Talks.
Thank you for having me.
So before we go ahead with the complexities of the debate, please tell our audience a little about the recently vetoed California AI bill and its key provisions.
Yeah, so Senate Bill 1047 was introduced by Senator Weiner, who largely represents the San Francisco region. And this bill would mandate that developers of frontier foundation models, and that's kind of a term that is used in the space to describe those particular models that exceed a specific computational power threshold, as well as a certain training cost threshold. And those are extremely, extremely large and costly models that we see with things like ChatGPT, really large language models. And those kind of developers have to take reasonable steps to prevent those models from causing or significantly enabling critical harm. So the bill defines critical harm pretty specifically to be looking at kind of chemical, biological, nuclear weapon capabilities resulting in mass casualties, cyber attacks above $500 million, any kind of real public safety or security risk, again, above this kind of $500 million threshold. And for companies who are developing these kind of products, they have to have some level of a model governance requirement, including the development of safety and security protocols, testing and auditing procedures, and the implementation of a quote unquote kill switch, right? So if something happens, they need to be able to have the capability to turn the system off immediately. And that also kind of accounts for any kind of models that are deviations from them, right? Because a lot of these developers sell these models to others who may be using them in different contexts. So they would also have to be submitting a compliance statement to the Attorney General. And then there's a couple other smaller requirements regarding employee notifications, whistleblower protections, know your customer requirements. And it would also create this board of frontier models within the California Operations Agency that would kind of be overseeing a lot of these different types of measures.
Why do you think that the governor felt that the bill SB 1047 posed risk to innovation despite its focus on accountability? Could the veto send the message that innovation is prioritized for the public safety?
Yeah, I think it is interesting and important to be focusing on Senate Bill 1047 because of this risk of catastrophic harm. It is valid. And at the same time, I think it's important to highlight in this conversation that Senate Bill 1047 was one bill in the context of 18 other AI bills that the governor did sign, right? So there has been a lot of focus on 1047, but there also was a lot of other really good legislation on AI that was looking to mitigate risks from AI, such as Senate Bill 942, which was focusing on generative AI, and same with AB 2013, again, focusing on generative AI and making sure that consumers are aware when they're interacting with a generative AI system. Again, this could be a large frontier or foundation model, but really starting to take that first step of, okay, making sure you are creating the system ethically and providing information to consumers about how such system was created. There was also other bills regarding deepfakes in elections and non-consensual intimate images. So it's kind of in this context that we have to be thinking about this veto of 1047. And with that, Governor Newsom, I speculate, I am not Governor Newsom, as you might expect, was assessing this balance between regulating AI, without overwhelming California's very large technology economy. And if you look at the veto message, you can tell that it really aligns with what he did sign, right? He really wanted to be focusing on these more high-risk use cases of AI, which we do see in some of these other bills that he signed. And also, to the extent his veto message almost said that it didn't go far enough because, again, it only covered frontier foundation models, which hit a certain computational threshold and certain cost threshold. So a lot of experts opine that that really only covers, at most at this point, two companies, maybe. And so a lot of these other bills that he was focusing on are less about the companies that are developing these really specific kinds of models, but more about the more risky uses of AI and how consumers can be more aware of how these systems are being used.
He also made it clear that regulation should be based on empirical evidence and science and not blanket measures that could slow innovation. Do you agree? And how practical is it to rely solely on science-based evidence given the rapid evolution of AI risk and the unpredictability of many of its consequences?
Yeah, I think it was a valid statement to make in that there are a lot of really concrete harms that we see with AI. And in terms of what we have been following in the US, there is a lot of evidence and documentation regarding bias and discrimination occurring from the use of an AI system, right? So if an AI system is not trained properly on data that is representative of the population that it's used on, then it's going to be far less accurate on those types of populations. So you see AI regulation in the US really focusing on that. There are other states like Colorado enacted an AI and anti-discrimination law. New York also has a similar AI and employment context law as well. Whereas the harms regarding these catastrophic events are less documented, right? Because it is a little bit more speculative. But at the same time, Senator Weiner has said also very validly that we may not want to wait for a catastrophic event to happen to regulate, right? Because that would, of course, be catastrophic. So how do we try to get ahead of that type of incident occurring without going too far into science fiction at the same time?
A lot of states have sort of, like you mentioned, Colorado, New York, who have mentioned anti-discrimination AI bills. I want to ask you that in absence of global regulation and um, standards, can individual states effectively regulate AI, considering its inherently global nature? Wouldn't differing regulation across region lead to fragmented framework, ultimately hindering innovation and complicating compliance?
Yeah, it's a really good question. And honestly, one that I think honestly has its start back in data privacy. So most data privacy laws, except for the US, have a comprehensive federal data privacy law, right? And there also was that question at the same time that a kind of fragmented data privacy approach would hinder business compliance, have a lot of different types of consumer rights across different jurisdictions, resulting in this fragmented framework, as you said. And yet, of course, data privacy regulation right now is nowhere near perfect. But for the most part, most jurisdictions globally and within US states have some level of a unified framework, right? We're still looking at data protection impact assessments, consumers' rights to opt in or opt out, right? They're all really similar in some level. And I think we're going to end up seeing something similar with AI because similar to data being very fluid, AI also very fluid, not really just sitting in one jurisdiction, being used across different borders. And we are seeing, while the states are really focusing in the US on hard law regulation, right? Things like the California bills that were signed, the Colorado AI Act, the New York City law. There's a lot of soft law approaches that are happening on the federal level, and they are trying to promote global harmonization. They are working with folks in the EU and in the APAC region and et cetera, to make sure that the standards for what they are thinking about align.
Even OpenAI and Andreessen Horowitz argued that Senate Bill 1047 would stifle AI development. Do you think that these concerns on part of AI tech companies are valid, or are they, overblown to avoid accountability?
Yeah, I wouldn't say either way. Honestly, in this space, there's a lot of stakeholders to consider. I know that's kind of an opt-out of an answer or a cop-out of an answer. But of course, when you're regulating a new product, there are going to be consequences with how that affects businesses who are developing that product, including changes with how that business operates, assesses their products, rolls them out, etc. But to many folks in civil society and consumer protection spaces, that's kind of the point with these kind of regulations. You're trying to incentivize moving away from this technology mantra of move quickly and break things towards something that is a little bit more slow and thinking a little bit more carefully about how these systems are created, how these systems are used, and how they interact with consumers or any kind of risks consumers could face because of them. So I think to your initial question and point regarding whether these concerns are valid, like, yes, of course, there's going to be a slowing of innovation because if you're going to have to comply with these, you're going to have to implement AI governance programs. You're going to have to make sure that there is a human in the loop, and all of these things may slow things down. But at the same time, if that is done at a level that is done well, it can be closer to move quickly, but don't rush, you know? And that's something that some other state legislators have talked about, that we can still innovate, but we just have to do it ethically and think critically about it.
The challenges of regulating AI aligns with what is termed as Colin Gridge dilemma, which suggests that while it is easier to influence a technology in the early stages, its risks are not yet known. However, once those risks become apparent, the technology is often too entrenched to be managed effectively. In your view, what strategies could help overcome this dilemma?
Yeah, so I think what's really interesting about the AI conversation right now is that AI technically isn't that new, right? It's actually been used, developed since the 50s, 60s, 70s, right? The financial sector has used it for a very long time at this point. So it isn't particularly new. We do have evidence of the kinds of risks that it poses, right? Garbage in, garbage out, inaccuracy, validity, bias, um, risks of hallucinations, things like that. It's when these tools started becoming more accessible for more people that we started to think larger about it, right? Because AI is really, in my head, more of an exacerbator of things. It's a tool. So everything that is good about society is likely to get much, much, much better. Everything that's bad about society also may get much, much worse. So when we already have that background of understanding, okay, the financial regulation was thinking about how to use these systems in these types of ways already. In data privacy law, there already has been provisions regarding automated decision-making systems, all the way going back to GDPR in 2018, even some earlier versions of data privacy regimes in France and other countries also mention automated decision-making technologies. So again, it's not always new, especially when there's some of these risks that have already been identified for privacy and bias and discrimination. And oftentimes those are a really good place to start because we know exactly what we need to be doing, the kind of guardrails that need to be in place. And then we can start assessing, okay, now that we have figured out that problem, let's move on to this next category of risk.
My next question is a little bit speculative one. How can lawmakers regulate AI risk without stifling innovation, especially in a state like California? And what key changes would you suggest to the vetoed bill?
Yeah, I kind of just alluded to, I think something that is a approach that we have seen in the US is there are kind of two buckets. One is a risk-based approach, and that is focusing on particular uses of AI in risky contexts, right? So AI being used to make a housing decision or to make an employment decision or to make a lending decision. Those are high risk uses. versus a technology-specific approach, which focuses, again, like what we saw with Senate Bill 1047, focusing on the particular frontier foundation model itself, or focusing on generative AI as a particular category. And a good place to start for a lot of states that don't already have some level of AI regulation is starting with the risk-based approach, focusing on AI being used in these really high-risk contexts. But in terms of Senate Bill 1047, it will come back. It actually has already inspired other kinds of state legislation in other states. So there is a very large question about how do you make such a bill that has good intentions to mitigate those risks, a more balanced approach, right? And a key way to do that is to start again with soft law, which is unfortunately still being developed really at the federal level. So you see the National Institute of Standards and Technology in the US are like currently working on how to develop standards for these really large foundation models and figuring all of that out. So once we're able to have better standards in place about how you develop these models, how to use these models, it can make it easier to mandate that through law or to be able to require folks to be adhering to those frameworks that are a little bit more technical in nature than the kind of risky uses of AI.
At the end, what insights can other states and countries gain from this veto in their efforts to regulate AI, especially as you mentioned that conversation around this law and this vetoed bill has already inspired other states and nations?
Yeah, I think one thing that's difficult to parse through right now is everything that's happening in AI right now. And there's been so much focus on this veto of SB 1047, which makes sense. But it does kind of miss the forest for the trees there, in that it's not the only bill that was happening in California, let alone the US on the state or federal level. There's a lot of activity happening here, the same way that there's a lot of activity happening globally. So in California, again, there was those 18 AI bills that were signed, also on top of the California Privacy Protection Agency, which is kind of the US's state version of a DPA, doing rulemaking on their data privacy law. And that includes rulemaking on automated decision-making technology. And the California Civil Rights Department is currently doing rulemaking on how to use AI in employment settings. And that's part of an entire country where things like the state of Colorado has enacted a law regarding AI and anti-discrimination. Illinois and New York have laws regarding AI and employment. And that's on top of all of the work that's being done on the federal level. So while there isn't any kind of hard law on the federal level, as a lot of folks have probably seen, it's just been the executive order, which doesn't have the same kind of force of law as a regular law passed out of Congress would. It does regulate how the agencies are using AI, which will have a trickle-down effect to how any kind of entities that work with the government, which is the largest customer in the US, are using these systems, and how different agencies are issuing guidance regarding how AI should be used, right? So the Federal Trade Commission has issued guidance. The Equal Employment Opportunity Commission has issued guidance. Again, National Institute of Standards and Technology, which is kind of a very large like science hub in the US, also working on standards. So there's a lot going on. And I think it's definitely important to make sure and understand that the US is by no means a kind of unified entity, but we are making strides in moving towards kind of comprehensive AI regulation.
Thank you so much for joining us today and sparing